Hello, hello, hello. How is everyone? Can you hear me? Oh, good. Hi, everyone. See, you get to see my face. So you can hear me okay? All right, good. A little blurry. I'm sorry. Have you tried changing your resolution on your side? Hi, Golden Girl. Hi. Hi, Nancy. There's Miss Cynthia. Hi, Mel. Hello. Thank you. That's good. Hi, Momo. Hi, Julie. Hi, Monty. Yes, thank you. You're stoked, huh? Have you tried changing your resolution on your side? Because what I see is fine. Is everybody else seeing it as blurry? Hi, Carolina. Oh, good. Oh, goody. Good. Hi, Southern Mom. Hi, Jennifer. Hi, Bad Moon. I'm sorry it was a little fuzzy at first. Well, I don't have fiber anymore, so that may be why. Hi, Susie. Yes, thank you. Oh, let's see what they say they've got. They've got 10 minutes. But we all know about Donna, right? Yeah, and Eric had me put in a description, and I did. I kind of added to that description from some other things that I found on, what was it, Long Crime or Court TV or somewhere. And it would not let me play my normal intro that I had made. So, that's something new. And if you hear anything, if you hear my dogs, sorry. Everybody's upstairs, so. Oh, well, you may hear some noise. Evidently, they have to leave. So, I'm sorry about any background noise. I think so. No, it's not my first live, Vanessa. I do have videos. I started last year. Oh, thank you, Susie. Oh, he just keeps droning on and on, don't he? Aw, number 33. Wow. Oh, thank you. Sorry about my bigger eyeballs. I just don't go live a lot. Oh, hi, Veronica. That's all right. Incognito's good. Protect yourself. Hi, Cindy. Yes, dogs will be dogs, but there just went the husband and the grandson, so now the dogs are down here. Hey, Miss KJ. Yes. Oh, and I know Monty was wanting. I got my hair cut. I got almost 9 inches taken off. So there you go, Monty. It's all whacked off. It was all down through here. It's so much better. Yes. Oh, thank you. Yeah, they were really shocked when I come in to get it whacked off because I hadn't seen a hairdresser in. See, my daughter's been gone for 3 years, so for about 2.5 years, I haven't been to a hairdresser. Thank you. Yes, and especially for work. Yes, I did. Okay. Oh, yeah. I wish. Hi, Kami. Hi, Mally. Yeah, she said I have healthy hair. I take really good care of my hair. Oh, hold on, boss man. Yes. There we go. Sorry about that. I forgot I muted myself. Not no more funk. I seen it. So it doesn't tell me how many people are here, so yes, easy peasy. But for my job that I do now, it cannot be below my shoulders, and my hair was to the middle of my back, and there was just so much weight. 42. Oh, wow. That's the most I've ever had in chat at once. I'm used to 5, maybe 10. Hi, Vanessa. You drive safe. Hi, Thomas. So, yeah, I've got her on. That's what Eric called about. Told me to go ahead and share my screen. No, thank you, Julie. Yes, for those of you that are new here, please go back and watch my previous videos. I do mostly missing children and adults, but mostly children. Oh, I see where my counter is now. How many people are here? But we do have a 53 Chevy that we take to cruise-ins and car shows, and I do have some shorts up with our car. So if you get a chance, just go look through. Hi, Kim. We are waiting on Donna Adelson, or Donna Gotti, for her motions hearing. This is my first time streaming anything from a court. Oh, wow. Thanks, Mally. Yes, Donna got a hee. Right, KJ? Does anybody ever think she's gonna flip? Just some of these criminals, you can tell, they just one little snap and they look like they could just flip out and go wild. You don't think so, Golden? Yes, she is shelling out the cash. Oh. Well, Eric, I didn't know that. Sorry. Let me do. Oh, here we go.
All rise. Court is now in session. The Honorable Judge Stephen Everett presiding.
Good afternoon, Your Honor.
Good afternoon, Judge.
We're here this afternoon in State versus Donna Adelson, 2023 CF 3226. Two motions we're here for this afternoon would be the defense's motion to compel and also the defense's motion to extend previously ordered deadlines for witnesses, exhibits, and pretrial motions in completing discovery. Part of the reason I believe we need to have a hearing on these matters as well, and I'll let you make your argument in just a moment, Mr. Zelman. Have you discussed with your client specifically as it relates to the raw data that you are seeking, specifically for Charles Adelson and herself, that this has the potential to reopening the door of the conflict?
Your Honor, I don't think that it would. It's in the same category as the emails that Your Honor authorized us to obtain in April. The raw, unredacted, unfiltered emails from our client's own account.
While they are certainly discoverable, and while you have an interest in using them to prepare for, the question remains, have you discussed with your client the possibility of this reopening the door to any conflicts?
No, we have not, because I don't think that it would reopen the door.
Very well. You may make your argument.
So, Your Honor, you may recall a number of times we've been before the court, and the defense, and as laid out in the motion to compel, we have been asking for the raw, unredacted downloads, the emails, and we were repeatedly told that that had been provided to us. When we were able to retain an independent forensic data expert and provided them with the materials that we had been provided, we were informed that those are not the raw forensic extractions. And I was asked to obtain the raw forensic extractions. And in the motion to compel, I actually cut and paste the expert's explanation. I'm not going to try to paraphrase it. It's an explanation that he provided as to why it is his recommendation that we obtain the raw forensic extractions. That's what I did. I've requested that. It's taken, we're now at a month since I made that further request, and I believe that we're entitled to that. I think the rule provides that, and our intent, in part, is to verify the cell brights that the state has prepared. The only way to do that, according to our expert, is to obtain the raw extractions from the state. And that's why we're asking for that, Your Honor.
Ms. Kappelman, you may respond.
No objection, Your Honor. I would just ask that whatever reports are generated by their expert as a result of that data being re-cell-brighted be provided to my office in a timely manner, because I'm advised, based on the version of the program and type of program they use to produce a report to verify our report, there could be some small differences involved. So I would like to not be surprised with that at trial.
Well, as to that, I will grant the defense's motion to compel. As to the issue of the conflict, specifically, Mr. Zelman, in part, when we had the first case management, I had counsel verify that they had no conflict as far as giving conflict-free representation to Mrs. Adelson. Should anything change with your review of these cell brights that may include communications from prior counsel or deal with matters that pertain to information that was provided by Charles Adelson, at that point, we are going to have to revisit the issue. Does everyone understand those?
Yes, sir. May I approach with a proposed order?
You may.
This is just the same one I had sent.
I don't have the name, because I don't have it.
Dave, if you copy the emails, Corbett is ready to do the upload evidence.
Okay.
Thank you.
And Your Honor, just to provide the report, Mr. Corbett and the defense expert have been communicating over the last 18 hours or so that once that order was signed, Sergeant Corbett was going to upload that to a portal that they've already tested this morning, so that our expert can download it. That'll be the fastest way for them to do that. He said as soon as Sergeant Corbett indicated that as soon as he was given instructions to start the process, he would do so.
Right. As to the second motion, the extending of all deadlines for the defense. In particular, we've already had 2 extensions that have been provided by the court, first from the April 30th deadline, second from the May deadline. Does the defense have any motions that are unrelated to the new discovery?
No, Your Honor.
All right. As to the motions that you believe you still need to file that are in some way related to this discovery, what is preventing these motions from being filed and you seeking leave to amend as necessary?
Your Honor, due to scheduling, we were only able to depose Mr. Newland and Sergeant Corbett Wednesday, Thursday. We are deposing Special Agent Pat Sanford, I believe, on this coming Tuesday. Before filing those motions, I think it's appropriate to make sure that there's a good faith basis to do so. And having those depositions, that testimony is, in my opinion, is necessary before we can do that.
Right. And I believe there are some other depositions that are scheduled for July, or I believe next week as well.
Yes, sir. We have them on Monday as well, maybe Tuesday and Thursday.
Part of the reason that we have, whether it be discovery or any sort of deadline cutoffs in any case, is not simply arbitrary of the judge just saying, get it done by a certain date. It is so we can proceed orderly to trial. I believe your proposed dates were to within 4 weeks of when you believe the state has fulfilled its obligation. That's when you would want to file your motions.
Well, Your Honor, given that we filed these on June 27th, we're obviously 2 weeks past that.
Oh, yes, we are.
And it's certainly not our intent to do anything to delay the commencement of the trial as scheduled.
The proposed date of when this would occur is not specific. It's not certain. It's pretty much a moving piece of jello. Is there anything that you can do to convince me that it's otherwise going to be a specific date in what you're asking to do with filing these motions several weeks after you believe the state has complied?
Unfortunately, it has been a moving target because we have not received all of the discovery from the state. During the depositions, during yesterday's deposition, we learned that he had conducted call frequency analysis between Donna Adelson and Charlie Adelson for a longer period of time than that had been previously disclosed. He is going to send us that if he had completed a report. He's also sending us the PDFs of the actual call frequency analysis that is contained in the demonstrative, because those are just excerpts of the call frequency analysis. So he's going to be sending us the completed call frequency analysis. So I say that to demonstrate that it is difficult for the defense to file any appropriate motions or to provide appropriate responsive either demonstratives or exhibits when we still have not received everything from the state.
At the same time, to file, and how many motions are we talking about at this point?
Potentially 3, Your Honor.
As to these 3 motions, would any of them affect the ability to actually move forward with the trial on August 19th?
No, I don't believe so. None of them are just positive.
Very well. Do you have any further argument in support of your motion?
No, Your Honor.
Ms. Kappelman.
No objection, Your Honor. We've just asked that we be given the same grace. I'm aware of at least one or two more things that the state intends to do that could, need to be done past the deadline. So all indications are that both sides are working diligently to get this done. I understand your comment about the Jell-O, and I've got a couple orders myself of Jell-O that I'm wrangling, so I'm trying to minimize it, but things do come up past the deadline, so we're going to have to work
Ms.
through those
Keppelman
things.
specifically asked these emails, which has contributed to this. What is it else that you believe is going to come up on the state's behalf?
The emails?
I said, other than the emails, what do you think is going to come up on the state's
There's a
behalf?
defense witness that's been listed that the state has discussed trying to depose and may try to get that done before the deadline. There's a handwriting expert that the defense is aware of, that a handwriting expert exists, but they haven't been given the name or the report yet. I don't have the report yet. So that's something that's pending that would be in violation of Your Honor's order. So there are a couple outstanding issues that I'm aware of. I was not aware of the issue that the defense just brought up regarding Corbett having done a report, but he does do work to generate the slides that were prepared and discovered by the discovery deadline. When asked about how did you come to those conclusions in deposition, he's going to say, I looked at the data. Well, they want to see that data. Okay, we don't object to that, but I don't think that's the same thing as a discovery violation.
The final pretrial hearing is August 8th. As to the date of when all motions need to be filed, so we can have a meaningful hearing on August 8th and proceed to an orderly trial on merits. These motions are going to need to be filed by July 21st. Any motion that is not filed by either the state or the defense by that date, the issues are subject to being deemed as waived. If you need to seek leave to amend as to the specific motions that will be filed on this date, you may certainly do so. However, again, this is not just arbitrary date making to throw something out. If we are going to in fact have a trial on the merits that will be orderly, both parties needed to see what you intend to raise as pretrial legal issues that the court needs to rule upon. There's not going to be a trial by surprise either for the state or for the defense. Am I making myself clear?
Yes, Your Honor.
Yes, Your Honor.
Will you state those dates one more time? Motions to be filed by July 21st and final motion hearings on August 8th. Is that correct?
The final pretrial hearing is on August 8th. This time has already been set apart by a previous order. As to the motions in limine that have been filed, I believe the defense has renewed its motion concerning the Latin Kings. Is that correct?
Yes, Your Honor.
The state filed any motion in limine by the previous deadline.
We renewed motions that were filed previously. There's nothing new.
Well, as previously ordered, copies of all of these motions, when they are filed, they need to be served upon the court. Please do so if you've not already done that regarding what has already been filed. I believe the next date that we will have, unless there are other issues that need to be addressed, will be August 8th. Does either party have anything it needs to raise?
Nothing from the state, Your Honor.
Can I have a moment, Your Honor?
Go ahead.
Nothing at this time, Your Honor.
Well, we are in recess for this afternoon.
Thank you, Your Honor.
You can, yeah, go ahead. What's that? It's good to file as is.
Did you enjoy your holiday, Judge?
Oh, the weather was good in both Maine and Canada. Could have been cooler, but it was nice.
Well, why am I not bigger? There we go. Hi, Gracie. Oh, thank you. Now I got a document that we can look at and read. Okay, yeah. I can actually, I don't think I can make it bigger. I don't know how to do that, so. This is an order on defendant's motion for change of venue. Oh, sorry about that. Okay. This cause comes before the court on defendant's motion for change of venue filed on January 14th, 2025. The court, having considered the motion, accompanying memorandum of law and affidavits, reviewed the record and accomplishing exhibits, held an evidentiary hearing, and being otherwise fully advised, hereby finds. Defendant has been indicted for first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. She is accused of committing offenses that occurred within Leon County, Florida, with limited exceptions to the Florida statutes mandates that criminal prosecutions shall be tried in the county where the offense was committed. Prompted by the temporary unsealing of an in-camera transcript, defendant requests that the venue of her pending trial be moved from the county where the offenses are alleged to have been committed. Nearly 3 months later, she filed an accompanying memorandum of law in support of her motion, along with multiple exhibits. The state opposes defense's request at this juncture, listing that the only way to determine whether an impartial jury can be impaneled in Leon County is by first attempting to impanel an impartial jury. And I think this was 7 pages long or something. To prevail on her motion, defendant has the burden to demonstrate that the setting of the trial is inherently I can't say it because of the general atmosphere and state of mind of the inhibits in the community. More specifically, the test for determining whether to grant change of venue is whether the inhabitants of a community are so infected by knowledge of the incident and accompanying prejudice bias, and preconceived opinions that jurors could not possibly put these matters out of their minds and try the case solely on the evidence presented in the courtroom. The Florida Supreme Court explained in Manning that a trial court could determine whether to challenge the venue for a trial prior to the commencement of the jury selection, or a trial court may, withholding, make the determination until an attempt is made to obtain impartial jurors to try the cause. As often occurs with the passing of time, legal precedents on a subject involves the most recent rulings from the Florida Supreme Court regarding change of venue require a trial court to make a two-pronged analysis. Trial courts are to alleviate the extent of the nature of any pretrial publicity. Sorry, have trouble with words sometimes. The difficulty encountering in actually selecting a jury. There are various factors for alleviating the pretrial publicity. And do you want me to read the whole thing or just go on down? Or I know some of it can be dry. One of those factors, whether the defendant has exhausted all peremptory challenges, even necessities proceeding to prong 2. The critical inquiry for prong 2 is whether any difficulty encountered in selecting a jury reflected a pervasive community bias against the defendant, Donna, which so infected the jury selection process that it was impossible to seat an impartial jury in the county where the trial was held. Both the extent and nature of the pretrial publicity and difficulty actually encountered in selecting a jury are crucial factors. Defendant would have this court reject these binding precedents and turn this into one-pronged analysis. The court declines to accept this invitation. Although it is undisputed that this case contains extensive pretrial publicity is normal and expected in certain kinds of cases, and that fact standing alone will not require a change of venue. And of course, it gives case law. Defendant's approach also ignores the long-standing principle that jurors with prior knowledge or even preconceived opinions as to the guilt of the accused can nevertheless serve on a jury if they can set aside their beliefs and render a verdict based solely on the evidence presented at trial. Consequently, the U.S. Supreme Court has declared to hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut the presumption of a prospective juror's impartiality would be to establish an impossible standard. It is sufficient if the jury can lay aside his or her impressions or opinions and render a verdict based on the evidence presented in court. Building on this prosecution, the Florida Supreme Court has previously determined if prospective jurors can assure the court during voir dire that they are impartial despite their extrinsic knowledge, they are qualified to serve on the jury, and a change of venue is not necessary. Even where every member of the jury panel had read or heard something about the crime, a presumption of impartiality is supported by veneer members' assurance that they would be able to discard the previously gained information and render a verdict based on the evidence presented in court. As a result, it is possible to impanel a jury comprising persons who can be relied upon and decide the case based upon the evidence and not influenced by knowledge gained from sources outside the courtroom. Then a denial of change of venue is proper. Defendant has provided no legal basis to forego the essential task of asking prospective jurors whether they can be impartial despite any potential extrinsic knowledge about the case, along with other vital questions. Furthermore, the court finds the hearing evidence does not demonstrate that the extent of the nature or of pretrial publicity is so pervasive that attempting to seat a jury would be futile. In conclusion, the court is mindful that nearly 70 years ago, the Florida Supreme Court declared that every trial court is considering a motion for change of venue must liberally resolve in favor of the defendant any doubt as to the ability of the state to furnish a defendant trial by a fair and impartial jury. However, the defendant has not provided a sufficient legal or evidentiary basis for bypassing the Florida Supreme Court's two-pronged analysis regarding a change of venue. The lump sum of traditional media coverage the defendant cites in her motion draws factual information from court records and proceedings. Defendant has not shown how the local reporting that compromises her evidentiary hearing exhibits is any different from cases where a change of venue was not required. The voir dire is appropriate for excluding prospective jurors who have been otherwise exposed to any inflammatory content. Moving jury selection from Leon County based on the current record before the court would reject the capability of all prospective jurors to set aside any preconceived opinions and assure that their verdicts will be based solely on evidence presented. It would also discard the firmly enabled principle of criminal jurisprudence that a person accused of a crime must, as a general rule, be tried in the community where the alleged crime took place, without first assessing a critical factor in the analysis for changing the venue. This does not mean that the defendant was unable to raise the issue of venue following voir dire. It simply means it is too soon to determine whether a change of venue is justified under Florida law. Simply, the court declines to grant additional peremptory challenges at this time. Defendant may renew her request for additional challenges after she has exhausted the number afforded to her by law. a trial court in its discretion may grant additional challenges and the law to a certain number of challenges, but there is no right to or entitlement to additional challenges beyond those established in that section. Ordered and adjudged that ruling is reserved on the motion for change of venue. Defendant may renew her motion following an attempt to actually select a jury. A change of venue will not be granted unless the defendant can demonstrate both prongs of the applicable Florida Supreme Court test. It is further ordered and adjudged that ruling is reserved on defendant's request for additional peremptory challenges until after she has exhausted the number afforded by law. What say you? Well, that is it. I think we will jump back over to Eric now. Back to Iowa versus Karina Cooper. And I will see you all there. I want to thank you all. I really, really, really appreciate you coming over here and supporting. Yeah. You're welcome. Thank you. You're welcome, Lori. Thank you. Wendi. Thank you. All right. I'll see you back over at Eric's. Bye.